Hi, I'm lawyer Jessica Bornick, and welcome to Legal Juice, a vlog of legal information, education, and entertainment. Today, I'm going to walk you through right here, right now, making your very own handwritten will. First things first, a disclaimer. Although I am a lawyer, I am not your lawyer. Should you require legal advice, please seek the assistance of a lawyer licensed to practice where you are. Do not rely on anything you see in this video as legal advice, and do not delay in seeking legal advice based on anything you've heard in this video. And if you like this video and you want to see more content like this, please be sure to like, share, and subscribe. Now join me as I go through step by step the elements of and the things you want to include in your very own handwritten will. Handwritten wills, better known in the legal community as holograph wills, are legally valid in most jurisdictions and are good enough to make if you're in a bind for time. Let's say you're going away on vacation or having last-minute surgery and you don't have time to make it to your lawyer's office. I do need to emphasize that although handwritten wills are legally valid types of wills in most jurisdictions, you still need to check the laws where you are to see if they're actually an option for you. I can say that at least here in Canada, handwritten wills are legally valid in Alberta, Manitoba, New Brunswick, Newfoundland and Labrador, the Northwest Territories, Nova Scotia, Nunavut, Ontario, Quebec, Saskatchewan, and the Yukon. They are not fully recognized in the provinces of British Columbia and Prince Edward Island. Now, Prince Edward Island only recognizes holograph wills for Canadian Forces members or mariners at sea. Similarly, if a will was written outside of British Columbia and it concerned property within British Columbia, then the will may be upheld in court. It is important that you write this document in as simple and plain language as you can so that your executor and any beneficiaries reading it will easily understand it. Because if not, they're going to need to seek legal assistance and perhaps make a court application for advice and direction. And that would cost your state more money than what you would have paid an estate lawyer to draft up a proper will. Now, holograph wills have 4 requirements to be valid. First, they must be wholly in the testator's own handwriting. Well, who's the testator? The testator is you, the person making the will. Wholly in your own handwriting just means that you have to handwrite the entire will out. You cannot type it up, and you cannot make a videotape testament like you'd see in the movies. The second requirement is that it must be dated by you. Thirdly, it must be signed by you. And lastly, there are no witnesses. In fact, if you have any witnesses signed, your will becomes invalidated. So let's begin. Take out a piece of paper and grab your pen. First things first, you need a clear intention that this is your will. So write, this is the last will and testament of me, Jessica Bortnick. Now here, of course, you're going to write your own name. Of the city of Edmonton in the province of Alberta. And again, you're going to write where you live, the city, town, village, that type of thing, and your province, territory, or state. The next thing you need to do is revoke all former wills and codicils. You only ever want one will floating around out there. Unless, of course, you have property in different countries and you're making complementary wills to each other. So neither of them are revoking the other. Or you have significant business interests and you're making a will specifically just for your business interests, okay? But those do not revoke each other. For the sake of understanding and clarity, and generally in most cases, you're going to want to revoke all former wills and codicils. People ask me what a codicil is. A codicil is basically an amendment to a fully typed up will, which is also known as a formal or solemn will. Now, formal and solemn wills are wills that are prepared by lawyers. Now, the next thing you're going to want to do is you're going to want to name an executor. And if you want to know what factors to consider when choosing who to name as your executor, I'll put a link to that video in my description. If you're in a happily married relationship or common law relationship, then you're going to want to appoint your spouse or common law partner to be your first named executor. And always make sure that you appoint a backup in case. All right. So I appoint my spouse, John Doe, to be my executor. In the event John Doe is unable to act as my executor, I appoint my sister Jane Smith to be my executor. Now, here in Canada, we've replaced the term executor with personal representative, but for the sake of understanding, I'm going to use the term executor in this video and probably in all of my videos. Now, you want to state that your executor has all the powers they need to get the job done, because if they don't, they're going to be stuck going to court to make an application for advice and direction or to get those powers granted to them. And anytime you go to court, again, it costs money, it takes time. So, my executor shall have all the powers necessary to carry out their duties in administering my estate in accordance with this will and the law. If you have minor children, this is where you want to name a guardian in the event of your death. And minor children here just means somebody who is not yet legally an adult. So they're either under the age of 18 or 19 in Canada. Now, I oftentimes get clients come in and they say that they want to name a couple to act jointly as their guardian. And what I suggest to my clients is that you name the person or persons you have the closer relationship with. So the closer friendship, the longest friendship, or they're related to by blood. Because marital and relationship breakdown has seemed to become the norm in society. And what happens if something happens to you and that couple is no longer together or they're no longer amicable? So here's what we're going to write. Should my spouse predecease me or on the death of my spouse, I appoint my sister Jane Smith to be the guardian for any minor children of mine. Now, if you're not married but you have minor children, then I would write, upon the death of my children's parent or the other legal guardian, and you can name that person, I appoint my sister Jane Smith to be the guardian for any minor children of mine. If there are no other parents of your minor children, then I would just state, I appoint my sister Jane Smith to be the guardian for any minor children of mine. And of course, Jane Smith here is just an example. You appoint whoever you want to assume this role for you. Now, start gifting away your estate. Make sure that you write down that your executor will first pay all of your legally enforceable debts and your funeral expenses before they gift away your estate. If you're writing your own will, it is okay to gift specific household items to specific people, but don't gift away a dollar amount to someone here, as your estate might not have enough money to cover that gift and pay all of your legally enforceable gifts. For instance, it's fine to gift away household items like, I give my wedding ring to my daughter, Samantha Doe, for her own use, absolutely. And we say for her own use, absolutely, because that means when she gets the gift, she can do with it whatever she wants. Most people don't make specific gifts in their will, so don't feel compelled to make a specific gift in your holograph will. Now, I suggest that you gift the rest and residue as you wish in percentages or fractions rather than dollar amounts, in case you don't have enough left at the time of your death to cover those amounts. If you're in a happily married relationship or common law relationship, then you want to gift to your spouse first, and then anything to your children or whomever else you want to gift your estate to. If you have no spouse or common law partner or no children, then gift your estate away as you see fit. And family, friends, charities, that type of thing are totally acceptable gifts. In fact, you can do whatever you want with whatever you have. Inheritance is a privilege, not a right. Now, I'm in a happily married relationship, so I'm going to write, I give, devise, and bequeath 100% of the rest and residue to my spouse, John Doe, for his own use, absolutely. Now, I'm going to put in the alternate beneficiaries here. Should John Doe predecease me or fail to survive me. Fail to survive me is key here. because every jurisdiction will have in its wills legislation a time frame that a beneficiary will have to survive the testator for them to be able to inherit their gift. Okay, usually it's 15 to 30 days. I direct that the rest and residue of my estate shall be divided equally among my children. Now, we need to talk about what happens if one of the children dies or they all die before they receive their entire share. So, in the event any of my children die before they have received their entire share, I direct such share shall be given to such child's surviving children. And then I'm going to put in brackets just for clarity, AKA my grandchildren. My grandchildren from that child. Now, if your children are really young or there's no grandchildren, then you might want to put in here something saying if one or more of your children die and they have no children of their own surviving, so no grandchildren, then their share will be split amongst the surviving children. So, should any child of mine fail to survive and not have children of their own, that child's share shall be divided equally among my surviving children. Now, if you have minor children, you probably want to set up a trust for them and make staggered payments. For example, 10% at the age of 18, 25% at the age of 21, and the balance at age 25. But we aren't going to get into that in this video. If you want to do things like that, then your best advice to seek legal advice from a professional where you are. Next part of it is you just sign and date. And again, no witnesses. If you have any witnesses to your will, as stated before, it will no longer be legally valid. Finally, store your will in a safe place like a fireproof filing cabinet, a safety deposit box, a safe, or even a freezer. Yes, you can place your will in a freezer. I do have a YouTube short that tells you where you can place your documents, and yes, it does involve your kitchen. Although a holograph will can be legally valid, again, check with your jurisdiction's laws to make sure that one will be recognized as legal where you are. It is best to have a lawyer prepare one for you. Be sure to subscribe and ring the bell to get notifications for the next video, which I'll be releasing next week about the benefits of using a lawyer to make your will. Thanks for watching.